We'll hear argument this morning in case number 20-1573, Viking River Cruises.
Mr. Chief Justice, and may it please the Court, the outcome here is controlled by this Court's decisions in Concepcion, Epic, and Lambson Plus. After those decisions, a state is not free to simply declare that a state statute is too important to be relegated to bilateral arbitration. None of the varying theories offered by respondent or the lower courts supports a different result. Respondent suggests that the waiver here is an invalid effort to immunize Viking rather than a valid effort to preserve bilateral arbitration. But Viking remains liable to Moriana for any labor code violation that she can prove affected her personally, and remains liable to the state for civil and criminal penalties. The only thing that is foreclosed is Moriana's effort to inject the facts and circumstances of countless other workers into this dispute, despite her agreement to arbitrate bilaterally. The Ninth Circuit viewed PAGA claims as more consistent with arbitration than class actions, but employer-wide PAGA claims are very similar to employer-wide FLSA collective actions, and Moriana's own complaint demonstrates the great difference between an effort to inject all manner of labor code violations for the entire sales force as opposed to Moriana's dispute about her final paycheck. The former requires a claim settlement process borrowed from a class action manual. The latter can be arbitrated in an afternoon. California's Supreme Court, for its part, said that PAGA claims are outside the FAA entirely based on a misplaced analogy to Waffle House. But Iskanian's theory that the PAGA claim belongs to the state and the state didn't agree to arbitrate would make all PAGA claims, whether individual or employer-wide, immune from arbitration, which would make the conflict with the FAA unmistakable. And the analogy to Waffle House is a non-starter. Here, the same party that is in court seeking to litigate on behalf of the entire workforce is the self-same party who agreed to arbitrate bilaterally. I'd welcome the court's questions.
Mr. Clement, if somebody else, a different employee of Viking Cruises, brings up PAGA action that by its terms would include Ms. Moriana, would she be able to be included among the group of people, the large group of people, that would recover under that action? In other words, she would not be bringing the action herself. It would be brought by somebody else, and she would be among that action.
I think, Mr. Chief Justice, that would still be foreclosed by the class arbitration PAGA waiver here. The provision is reproduced on page 13 of the blueprint, but it has essentially two subsections. The first involves the employee saying that they won't bring a class action, a collective action, or a private trade. And it continues to say that they won't participate in a class action, a collective action, or a PAGA action. So I would think that based on the contract that Moriana has foreclosed her ability to essentially benefit from that kind of employer-wide PAGA action. But if I'm wrong about that, I don't think it changes the outcome in this particular case. I think here the important thing is that this action shares the fundamental attributes of a class action and a collective action that make them inappropriate for traditional bilateral arbitration. They aggregate multiple claims in a single proceeding with heightened stakes and wide discovery.
Well, but this is what strikes me as one difference is that this is not her cause of action. This is the state's cause of action. It is an action, it's the Attorney General's action. She's acting not really as, would be acting not simply as herself, but as a delegee of the Attorney General, and would be securing the recovery for the state as well as for other employees.
But Mr. Chief Justice, I don't think that's the critical feature of PAGA. It's certainly not what we object to. So if Ms. Moriana wants to bring an individual PAGA action, assuming that that exists, if she wants to bring that into arbitration and 75% of the recovery of the penalties provided by that statute go to the state, Viking has no objection to that. So it's not the state's involvement here as sort of a latent real party in interest, however you want to characterize them. That's not the gravamen of our concern. The gravamen of our concern is that this action is not just trying to litigate Moriana's labor code violation, but the labor code violation of essentially the entire sales force.
But that is what the state has decided is necessary to adequately enforce its own labor laws. I mean, the state has made a decision here, and we don't have the capacity to do this ourselves. We need private people to do it, and we need private people to do it in this way. They're not going to come in with a claim for $2.32. So this is a state decision to enforce its own labor laws in a particular kind of way that the state has decided is the only way to adequately do it. And essentially your position says, you know, the state just can't make that decision, even though that's the way that the state has decided best serves its sovereign interests.
At the end of the day, that's right. But the state made a decision in Concepcion, and this court said that that state decision has to yield. And I don't think it's functionally different. I mean, a state could say, boy, enforcing our labor code is really important, so we are going to provide particular penalties that are only available in a class action. And then if somebody tries to invoke their class action waiver, we'll say, aha, you can't invoke the class action waiver because we've put these penalties behind a firewall. They're only available in class actions. So now you're not just waiving the class action, you're waiving these substantive penalties we've put behind the class action firewall. I don't think
I mean, it's an honest answer that you just gave, but I'm wondering whether anybody, when they were enacting the FAA, about, you know, making sure that people could agree to arbitrate and making sure that courts would not disrespect those agreements, whether anybody thought that the FAA was going to end up precluding the ability of the state to structure its own law enforcement with respect to labor violations. You know, just to say to the state, you can't do things a certain way, you can't enforce your labor laws in that way.
So, Justice Kagan, I mean, it's an interesting question whether the FAA, the Congress that passed the FAA in 1925 would have foreseen the kind of class actions at issue in Concepcion, the kind of collective actions that were provided for in the FLSA that were at issue in the EPIC case, or whether they would have foreseen this particular kind of PAGA action. But I do think that certainly if we take Concepcion and EPIC and LAMPS Plus as a given, and nobody's asked you to overrule those cases here, the logic follows directly that just as the state can't say, you know, these class action waivers in the consumer context, that's not something that we really cotton to here in California. We're going to find those sort of categorically unconscionable. This court said that state policy had to yield. I don't think the state policy here is any more sacrosanct. And I do think it's worth noting that this is a very anomalous statute that's at issue here. I think it's telling that no other state has showed up to participate as an amicus in this case, and I think that underscores what an outlier this PAGA remedy is. It's an exceptionally good device if you're trying to circumvent the Concepcion and EPIC decisions, but it really is an outlier in terms of what...
It may be, but I tried to take right on a list. What are the differences between this and a class action? There are quite a few. I mean, one of them is you're not looking at the damages of the other employees, just trying to see if there's a violation of the code. That this employer did respect some other employees, and the money then is sent and goes to California, and they distribute it to the state. And then some other ones are that there's no right to receive notice, or no right to intervene, no right to object, but there is no appeal from the settlement approval, there's no procedural formalities, Rule 23 doesn't apply, there's no numerosity, there's no commonality, there's no typicality, there's no representation. In all those procedural things, on which there are a lot, the arbitrator doesn't have to go into. I mean, it's not a class action. It's more like a qui tam action. I never heard that you couldn't agree to have an arbitration of a qui tam action. Why not?
So, Justice Breyer, when you tell me all the things that aren't present in these kind of actions, I sort of get chilled down my spine, because many of the things that you're talking about are things that are the essential protections for a defendant in the class action. Sure, some of them are there to protect absent class members as well, but they are the things that keep a class action within the rails.
Yes, so in fact, I guess, if there's some problem of due process or something with that, if there was no arbitration agreement, and this individual brought a PAGA action in a court, it would be the same. So if you think it's unfair to the defendant, it's unfair in court. It's unfair wherever you go.
But there's two critical differences that make PAGA actions really exactly the same as class actions, and I think they're the two things that are most material for purposes of applying Concepcion and EPIC. One of them is that you have massive liability. Sure, it's not damages, but the penalties here are actually larger than the damages associated with most of these labor code violations. So you have these massive claims in terms of their monetary amount. And the massiveness is not driven by the inherent nature of the claim. It's driven by the aggregation of multiple claims.
But you're not suggesting that the state could bring this lawsuit, is that right? And the state could do it in this completely aggregated way.
I think that's right, and then the state would bring it in court, and that really gets to the second piece of this, which is the critical thing is if you have these massive damages from aggregating claims, and then you have, California's made it clear that the discovery in these PAGA actions is coextensive with discovery in class actions. So courts are very good at dealing with those kind of discovery issues. Arbitrators are very bad at dealing with class-wide discovery. And at the same time, given the high stakes because of the aggregation of the claims, if I'm a defendant and you're telling me I can't escape this kind of aggregate litigation, it's going to happen. It's going to happen to me either in arbitration or in litigation. Then I'm going to pick litigation every time because I get lots of additional judicial review and judicial remedies available to me there. And what that's going to mean in practice is that arbitration is going to wither on the vine.
Okay, so what you're saying, so your point, I just want to be clear on this, is that if you win, then
We'll hear argument next in case 21-248, Berger against North Carolina State Conference of the NAACP. Mr. Thompson.
Mr. Chief Justice, and may it please the Court, North Carolina law designates the state as necessary parties, the petitioners as agents of the state, and as necessary parties in all actions challenging state statutes. When such actions are filed in state court, the petitioners are defendants and necessary parties. This lawsuit, however, was filed in federal court, and when the petitioners sought to intervene, they were denied, and a strong presumption was applied against their intervention. This outcome should be reversed for two reasons. First, under Turbovich, we are entitled to intervene. The state respondents have candidly and forthrightly acknowledged that they have a primary objective in receiving clear guidance on what law, if any, will need to be enforced. And because that administrative responsibility and interest may not always dictate precisely the same approach to litigation as our interest in defending the law every step of the way, we are entitled to intervene under Turbovich. Second, this case presents foundational issues of federalism. This court recently in Cameron held there are deep constitutional considerations implicated when a federal court is called to pass upon the constitutionality of a state law. And thus a federal court must account for a state designating multiple officials to defend its sovereign interests. There is no basis in this case for a federal court to second-guess a state's decision that it needs a representative exclusively focused on vindicating state law. I welcome the court's questions.
You said there's no basis in this case. Is there a situation where you would think it was appropriate for the federal district court to deny intervention where the state law provided specifically that particular state officers be afforded that right?
Well, Your Honor, we'd have to go through the multi-step factors of number one, Donaldson. We need to make sure it's a significantly protectable interest that was identified. Number two, we need to look.
Your argument next in case 21-309, Southwest Airlines versus Saxon. Mr. Dorefsky.
Mr. Chief Justice, and may it please the Court.
Section 1 of the FAA exempts only classes of workers that work on an instrumentality of foreign or interstate commerce, like a plane, ship, or train, as it moves goods or people across borders. That rule follows from Circuit City and Section 1's text and structure. Circuit City held that the exemption reaches only classes of workers engaged in foreign or interstate transportation. As then Judge Barrett held in Wallace, that means an exempted class of workers must perform work analogous to that of seamen and railroad employees. Seamen and railroad employees' key characteristic was working on ships and trains. We know that because seaman was a term of art. It meant workers who predominantly worked on a vessel. Vessels, by definition, transported or were capable of transporting goods or people over water. And the paradigmatic seaman, as the court noted in Njjjar, sailed long voyages. That made seamen as a class actively engaged in foreign or interstate transportation. Critically, seamen did not include land-based maritime employees. By specifying seamen, Congress excluded stevedores, who are land-based cargo loaders. Now, Saxon says the exemption covers the entire airline industry. But Section 1 exempts classes of workers, not industries, engaged in foreign or interstate transportation. It says seamen, not maritime employees. It repeats foreign or interstate, emphasizing border crossing. And placed among these other words, railroad employees similarly means workers who perform their duties on the train. Saxon is not exempt from the FAA. Cargo loaders don't work on planes, just as stevedores didn't work on ships. They load cargo before other classes of workers, like seamen and pilots, do the foreign or interstate transportation. They may facilitate transportation, but that's not the test Circuit City requires. I'm happy to take the court's questions.
Counsel, we'll hear argument this morning in Case 2603, Torres versus Texas Department of Public Safety. Mr. Tutt?
Thank you, Mr. Chief Justice, and may it please the Court. The Constitution gave Congress the power to raise and support armies, and the reason for that grant was to ensure the survival of the nation. The Constitution provided Congress with the tools necessary to fulfill its preeminent national defense function, and the ability to authorize lawsuits, including suits against the states themselves, are among those vital tools. I'd like to make two additional points this morning. First, the war powers, including the Army and Navy clauses, are unique and fundamentally different from the Constitution's other grants of power. Unique textually, unique structurally, and unique historically. The states could not have read the Constitution, seen the federal structure it created, and believed they would retain sovereign authority to interfere with the federal government's preeminent national defense function. Second, USERRA's protections are crucial in light of the structure of the modern military. At the turn of the 20th century, it became apparent the United States would be required to wage war on a global scale, and at a moment's notice, and that this would require an immense fighting force. Rather than create a massive peacetime standing army, the United States instead created a reserve component, trained soldiers who would keep their civilian jobs